Based on the prosecutor, we have not seen any letters or heard anything in that regard yet. The prosecutor submitted a sentencing memorandum that made mention of the family, but perhaps we may hear something along those lines during elocution, Your Honor.
So we'll reserve that until after elocution. OV6, it's scored at 25 points. Any objection, Mr. Dodge?
No, Your Honor.
Mr. Fisher, any objection?
No, Your Honor.
And that brings us to, I think OV13 was scored on by the DOC, but I think everybody agrees that's 0, correct?
Correct.
Yes.
And then OV19, Mr. Fisher, what's your position on OV19?
I believe that should be scored at 10 points for the obstruction of justice by the defendant, fleeing the scene, fleeing the officer's commands, and the 5-hour manhunt that ensued. He obstructed the administration of justice at that point.
Mr. Dodge?
Your Honor, I know we submitted a rather lengthy objection in writing on that issue, but long story short, the evidence we argued showed that defendant left the scene prior to any police commands, any police presence being shown. He left the scene, and we don't think that fleeing the scene in and of itself would justify OV19. There were then subsequent police commands given in the dark, nothing indicating who they were given to. And when Mr. Taylor was finally approached by police the next morning, we heard nothing but cooperation on his part. So we don't think that fleeing in and of itself from a scene would justify scoring of OV19.
The court obviously was present during the course of the trial, and the court does believe by the greater weight of the evidence that the defendant was present when the officers told him to stay put or freeze. It's night, there wasn't a lot of background noise, voices carried at night. In addition, the weapon itself was removed from the scene and ultimately had to be located at a later point in time in the weeds by a canine that was tracked to search for weapons and firearms. So there was a removal of the firearm from the scene and disposed of. In addition, the defendant disregarded the lawful commands of law enforcement. So OV19 is going to be scored at 10. And Mr. Fisher has an issue on OV7.
Your Honor, I do want to back up just a minute. I'd like, can we discuss OV9? We did not discuss that.
Let's go to OV7 first.
Well, okay. All right, OV7, Your Honor. The people believe that OV7, offense variable 7, aggravated physical abuse, should be scored at 50 points due to the evidence at trial that established excessive brutality. Excessive brutality, in this case, is established from the evidence that the defendant shot Aaron Barlow, an unsuspecting and defenseless victim, 6 times from point-blank range. The evidence at trial proved that the shooting was done in such a cold-blooded manner that the charge of manslaughter was not even requested by the defense as a lesser charge for the jury to consider. In People v. Hardy, 494 Michigan 430, the court held, quote, a trial court can properly assess 50 points under OV7 if it finds that the defendant's conduct falls under one of the 4 categories of conduct listed in subsection 1A. Excessive brutality is one of those 4 categories found in MCL 777.371A. People argued that it was excessively brutal for the defendant to shoot Aaron Barlow 6 times from point-blank range. This would be going beyond what would normally be considered as necessary for committing a crime of murder with a pistol, perhaps 1 or 2 shots, not 6. People also submit, based on the testimony of Dr. Stephen Cole, that Aaron Barlow would have lived a few minutes after being shot, that he would have been aware that he was being shot multiple times. The people believe this conduct of the defendant would have certainly have substantially increased Aaron's fear during the shooting and for whatever time he survived thereafter. Based upon the facts and circumstances of this case, the people respectfully request the court score OV7 at 50 points.
Mr. Dodge.
Now, we do not feel that, based on case law, that the facts here alleged would rise to the level of sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear. I believe what the court heard was there was 6 successive shots in the midsection of the deceased. It's not as though, shot in the leg, delay, shot in the other leg, delay, type of just torturous activity. So we don't feel that the fact that there may have been 6 shots itself would justify scoring here. And I think we feel the case law would have the facts here scored at 0 points, Your Honor.
Thank you. We're dealing with second-degree murder, and frankly, all of these offenses are brutal. They are. And while it may seem counterintuitive to say, well, how can brutality not be scored when you have 6 shots fired? But again, the nature of the offense itself is brutal. And this offense occurred within a couple of seconds. It was, frankly, 6 quick shots. So was it brutal? Yes. But as far as prolonging the pain and suffering, as Mr. Dodge indicated, if there was a shot, even then a couple of seconds wait, another shot, there's areas of the body, that would indicate almost sadism, torture, or excessive brutality. We have here a rapid succession of 6 shots. The court does not believe that the case law supports scoring of 50 points under these circumstances. It certainly shows the intent to kill, but it does not show excessive brutality. It shows brutality. So OV7 scored at 0. That leaves OV9, multiple victims, Mr. Fisher?
Yes, Your Honor, I think when we were going through the scoring guidelines earlier, I think we skipped over OV9, and I'd ask you that be scored at 10 points as well.
Mr. Dodge?
Your Honor, based on the reasons submitted to the court, we would argue that OV9 be scored at 0 points. There's insufficient proof that James McGee was in the passenger seat of the vehicle to be placed in danger of personal injury, and that his behavior that he explained after the shooting just does not coincide with somebody that would have been shot towards.
Well, one doesn't know how one would react if 2 friends that were good friends and one inexplicably executes the other buddy and you're seated 2 feet away, or it's probably 6 inches away. How does one react when that occurs? Nobody knows. Obviously, Mr. McGee was upset and shocked, scared, and he indicated at trial that he thought he could have been killed. And if one of the rounds had gone through the victim and struck Mr. McGee, he could have been killed. So certainly, it's going to be scored at 10 points because Mr. McGee was placed at risk of harm of an errant round striking him. And as he indicated, placing his family at risk because of his loss. So 10 points is scored at OV9. So I've got a total of 115 points on the OVs. We've got them in an A3 grid. Is that accurate?
I believe so, Your Honor.
Is that correct, Mr. Dodge?
That would be-
Assuming that OV5 is scored, which I haven't made a final decision on. Would you take your client to the wall?
Sure.
We have victim allocution.
Barbara, you come first. Aaron, this is Barbara Norman. She is Aaron Barlow's mother.
Good morning and welcome.
Good morning, Your Honor. Your Honor, my name is Barbara, the mother of Aaron Barlow, whom we lost in a tragedy that has irreversibly shattered our lives. Today I stand before you a mother enveloped in an endless abyss of grief, carrying a heart that breaks each new morning. The loss of Aaron, my child, is a pain so deep and pervasive that it defies description. It leaves a void no words can fill. Since my son was taken from us, not a single day has passed without an acute awareness of his absence. Our family gatherings, they have one less laugh. Our holidays has one less seat at the table. And every family milestone is teamed with the shadow of what should have been. The psychological and emotional trauma inflicted upon us is immeasurable. We are haunted by the loss. We plagued with nightmares, and we gripped by a sadness that is constant as it is deep. Aaron was not just a son. He was a beacon of kindness in our lives, a man whose future was as promising as his presence was uplifting. His untimely death has left scars not only on our hearts, but on the very fabric of our community. The emptiness left by his passing cannot be overstated. The ripple effects of this loss will be felt for generations within my family. James, convicted of second-degree murder, stole more than just a life. He robbed a family of a cornerstone, a community of a bright light, and the world of potential force for good. It's a loss from which we will never recover. And it is a breach of societal trust that cannot be easily mended. Oh, Jesus. In light of the profound suffering and irreversible harm caused with the heavy burden of ensuring that no other family should endure such a grievous loss, I respectfully implore the court to consider the maximum penalty, a life sentence. This sentence is not just a punishment, it is a necessary measure to prevent the possibility of this tragedy repeating itself at the hands of the same individual. Your Honor, as you deliberate on the sentencing, I just ask you to consider the life that was lost, the lives forever altered, and the safety and well-being of society. Granting a life sentence is not going to bring Aaron back, but it may offer a semblance of justice and safety, ensuring that no other mother has to stand here where I am today. Thank you for allowing me to speak on behalf of my son Aaron and our shattered family. We trust in your judgment and pray for a resolution that honors the severity of this crime and the indelible loss that we endure today. Sincerely, Bob.
Thank you very much for your comments.
Here she comes.
Good morning and welcome.
Your Honor,
And you are?
my name's Choya, and I'm the sister of Aaron Barlow, whose life was prematurely taken by James. Today I stand before you not just a grieving sister, but as a voice for the justice that Aaron deserved, but will never see. From the day we learned of Aaron's murder, a fire of anger and outrage has burned within me. Aaron's death was not a tragic accident. It was premeditated, a premeditated act from James. He didn't just murder my brother. He planned and plotted to take away a life cherished by many. This act has shattered our family, leaving us with a void that can never be filled, a pain that never subsides. My brother was a man of kindness and integrity, qualities that the world is deprived of because it calculated act of violence. His absence is a consistent, present void that echoes through every moment of our lives. Aaron's nieces and nephews have lost a role model. Our family has lost a beloved member, and I have lost not just my brother, but my confidant and number one supporter. I urge you, Your Honor, to consider if it was your own son, brother, or father whose life was so brutally snatched away. How would you judge the killer? This perspective is not to provoke, but to invoke the depth of empathy that's required to understand our level of torment. James deserved to spend every remaining day of his life in prison. Not only does he need to be removed from society to prevent this from happening or harming anyone else, but he also deserved to see the face of my brother every single day. He needs to face every consequence that he deserved. I want him to be hunted every single day of his life. I want the reality of action to weigh on him relentlessly. Furthermore, I want him a life marked by the same loss and suffering he has imposed on us. It's fitting that he experienced the death of despair that he has brought to my family. As you deliberate on this sentence James as you would if it was your own loved one who was the victim of this. We ask for no mercy. As now was shown to Aaron, we need a verdict that reflects the severity of James' actions and ensure he can never harm another soul. Thank you for allowing me to express the storms of feelings that I carry. We look to you for justice, the kind that speaks clearly to the value of life we treasure and the cruelty with which was placed and taken from us.
Thank you. Good morning, your name, ma'am?
Good morning, Dorian Gaines. Aaron Barlow was my brother. I don't have much to say to the feces that's locked up over there. I'm just asking the court, I'm asking you to look at the crime that he did. He took my mama's son, my brother, my kid's uncle, my grandkid's uncle. He took my auntie's nephew. He took my first cousin. I'm a little upset with the system, but I think you're gonna make it right for us today. We hurt. We gotta deal with the ramifications that this coward did. I refuse to say his name. He don't even get that from me. But I do believe in justice in a little bit different way than we standing in this court, and I got a feeling God gonna return the favor. Thank you.
Thank you. Anything further, Mr. Fisher?
Your Honor, that's it as far as victim impact statements. I do have a positional argument to make on the
Mr. Guy.
sentence.
Yes, Mr. Fisher, you may proceed.
Thank you. Your Honor, the people believe the facts of this case justify a minimum sentence exceeding the sentencing guidelines range maximum of 270 months. There are several factors that support an upward departure from the guideline range. First is that the defendant has not shown any remorse for the killing of Aaron Barlow. The evidence to support this comes from the statements made by the defendant in the recorded jail telephone calls. In those calls, it's very apparent the defendant is more upset about his friend, James McGee, breaking some sort of code by cooperating with the police after the shooting. There's a constant theme from the time the defendant made his first phone call in March of 2023 through the end of that year that the defendant is angry about that his best friend cooperated with the police and testified in court. And there were numerous statements presented. I'm not going to read through all those and go through all those. There were numerous statements presented at trial to show that this was his primary concern. He's shown no remorse, Your Honor. The defendant also made the following statements, and I'm going to talk about some of these statements. In his August 5, 2023 phone call to his girlfriend, Rihanna, from the jail. Quote, like, yeah, to me, honestly, I don't see how any crime is past 5 years, close quote. Quote, goddamn, okay, I understand somebody's life is gone, but you get them life for that, question mark. You know what I'm saying? You get them life for that, but that's life suffering. It's not bringing the person back, so how is that justice? You get what I'm saying? How is that justice when it's not bringing the person that's gone back in no kind of way? It's just making somebody suffer. So how is that even better than what the hell happened to the person that's gone? Because the person that's gone ain't suffering no more. That was a moment of pain. Now it's over with. These statements by the defendant are alarming and show a complete lack of remorse, empathy, or any understanding of how his actions affected Aaron Barlow, his family, or the community. People believe that the defendant, who now has been convicted of murder, who has this type of mindset, is certainly a true danger to public safety in the future. His views of crime and punishment are chilling. It's obvious from his statements that he takes no responsibility for his own actions. People argue that the brutal nature of the offense is also a justification for exceeding the sentencing guidelines. The defendant shot Aaron Barlow 6 times from a point-blank range without any justification. The way the defendant did this, together with the location of the gunshot wounds, proved that he certainly intended to kill Aaron Barlow. The shooting was senseless and committed by a person who believes he should not be responsible to pay any penalty greater than 5 years in prison. People are respectfully requesting this court hold the defendant accountable by sentencing above the sentence guideline range. And the court may depart from the sentence range established under sentencing guidelines if the departure is reasonable and the court states on the record its reasons for the departure. The sentence must consider the nature of the offense and the background of the offender, and it must be proportionate to the seriousness of the circumstances surrounding the offense and the offender. Departures are appropriate where the guidelines do not adequately account for important factors legitimately considered at sentencing, and where the recommended range under the guidelines is disproportionate in either direction to the seriousness of the crime. Relevant factors for the court to consider may include, among others, 1, the seriousness of the offense; 2, factors not considered by the guidelines, such as relationship between the victim and the aggressor, the defendant's misconduct while in custody, and the defendant's expressions of remorse, which there have been none. In fact, quite to the contrary, it shows a complete lack of remorse. And the defendant's potential for rehabilitation. Now, even if this court does not agree with the scoring request by the people, there are ample reasons and justifications to exceed any guideline range. In truth, no amount of time the defendant is sentenced to will be adequate to the pain and hurt the defendant has brought upon the family of Aaron Barlow. The people are asking this court to sentence the defendant above the sentence guideline range, or alternatively, to at least 270 months in the Michigan Department of Corrections, which is the top of the agreed-upon guideline range for the crime of second-degree murder. Thank you.
Mr. Fisher, you asked the court to go above the guidelines and the reasons for that. What is the amount of departure that you're asking for? That needs to be based in the record, and not just reasons for the departure, but the amount of departure. What is the amount of departure that you're asking for, and on what basis do you make that calculation?
Well, Your Honor, there's a number of reasons I would ask the court to depart.
I get the reasons for, but now you have to look at the amount of
Right.
departure. Upon what is that based? How do you get calculations like, you've seen me do it in the past when I've
Right.
done guideline,
Right.
over guidelines, and there needs to be reasons, not just for the departure, but the court must also justify the amount of departure. And I'm asking you to justify what you believe the amount of departure should be.
Your Honor, I believe in this case, and speaking with the family of the victim and other people involved in this case, that this should be a minimum sentence of 30 years plus the two years for felony firearm in this case.
Thank you.
Thank you.
Mr. Dodge. Mr. Taylor. First of all, Mr. Dodge, regarding OV5, what's your position on OV5?
I think that based on the statement by the victim's mother that would reach that threshold.
Would you agree with that, Mr. Fisher?
I would, Your Honor. I believe that we also supplied to the court a record or some indication that a great nephew of Mr. Barlow, who he was helping to raise, is actually in counseling as a result of this incident.
So I've got 115 for the OVs, he's an A3. All right, Mr. Dodge, the floor is yours.
Thank you, Your Honor, and I know that the defense supplied the court with a rather lengthy sentence memorandum, as well as, I believe there was 9 character letters from friends and family of James Taylor. And Your Honor sat through the trial on this case, as far as what a difficult case this is all the way around. What we believe even came out in trial is a positive background on the part of Mr. Taylor here. But Mr. Taylor, the jury found Mr. Taylor guilty of second-degree murder. The law, through the sentencing guidelines, contemplates a minimum punishment when someone's convicted of second-degree murder. Prior record variables. Here, Mr. Taylor scored at 0 points. Offense variables also taken into account. So we would submit to the court that the law, through the sentencing guidelines, and obviously murder, one of the most serious charges that comes before the court, but that's contemplated in the law through the guidelines. We would request the court sentence the defendant, Mr. Taylor, here to the minimum end of that, to 162 months. Prosecution's arguing for the court to go above, factoring in the alleged offender and the crime here. The offender's factored in the guidelines. There's cases where the person's off the charts on prior record variables. They're just coming back over and over and over, getting in trouble with the law. That's factored in here. He's a PRV 0. Offense variables, same thing. Sometimes it's off the charts on offense variables. And the guidelines, the variables just don't take into account the excess, the aggravators, excessive aggravators on the part of the defendant. Here, we don't even hit the ceiling for offense variable scoring. So we would ask the court to stay within the guidelines. Obviously, we had argued for a lower guideline range, but if the court's inclined to score the defendant at 162 to 270 months, we would ask the court to sentence Mr. Taylor to the lowest end of the guideline range. Does that bring back Mr. Barlow? No, but the law contemplates a second-degree murder conviction and sets those basic parameters for the court to consider. As the court read through, Mr. Taylor was living a very good, positive lifestyle. The whole case is a mystery, okay? But he was living a good, positive lifestyle. As the court saw, he may have gleaned a good, positive family support system in place, much as it looks like Mr. Barlow enjoyed, but good, positive people. And that's why when the court's considering rehabilitation, reintegration back into society, when that day comes, the prognosis is good for Mr. Taylor to get back out with his work ethic, with his strong pro-social family and friend support, to reintegrate into society and continue to be a productive member of society and to provide for his children and his family. Your Honor, Mr. Taylor had no beef, no issue whatsoever with Mr. Barlow. They got along quite well. James, as you can glean from those letters, he's a positive, pretty happy-go-lucky person. It just doesn't add up, but the jury found Mr. Taylor guilty. I'd ask the court to please not get too caught up in the phone calls, okay? Those are snippets, bits and pieces of 1,500 phone calls pulled out, hearing the stories of other inmates talking about the difficulties they've lived, reading books on history of incarceration, philosophies, issues like that, and then knowing he's on a recorded call, just having kind of broken up conversations on some of these topics. It wouldn't be a lack of remorse to Aaron Barlow. It's just more going through this past 16 months struggling. How did I get from working, supposed to go to a ball game with my dad and my grandpa next week, to being confined on this type of offense? It's been difficult to fathom and comprehend. It's been a roller coaster emotionally on Mr. Taylor, and that's not to take away from the emotional roller coaster of the Barlow family, okay? It's been difficult So some of these little snippets, bits and pieces that are pulled out of 1,500 phone calls just don't give full context to some of these issues and struggles that Mr. Taylor's been contemplating. 162 months plus 2 years, Your Honor, is a significant amount of time for an individual with a rather minimal prior record, an individual that's never had a history whatsoever of gun violence, and we would submit no history of a danger to the public. In his 33 or so years old, he's never been a threat to the public. In fact, the court heard him. He lives a pretty responsible lifestyle. He's given the trust of driving trucks alongside the public. He's a responsible person. So we would ask the court to go to the lowest end of the guidelines, that that's sufficient under the facts of this case here, Your Honor, and that the law through the guidelines contemplates an individual such as James Taylor that may come into court on a second-degree murder with a PRV level of 0. So we would ask that the court sentence Mr. Taylor to the lowest end of the guideline.
Thank you. Does that conclude your comments, Mr. Dodge?
It does, Your Honor.
Mr. Taylor, have you had an adequate opportunity to read and review the pre-sentence report?
Yes,
Any additions or corrections that you wish to make?
not as far as that.
Anything you would like to say before sentence is imposed? We'll just slide over to your left a little bit so we make sure we pick up your voice.
I want to start by saying that this situation, given that this is the first time I get to speak, has not reflected who I really am as a man, my character, and as far as the family. I mean, I understand that I'm the only in their life right now, and it tugs in my heart that I gotta be looked at this way, because it definitely is not who I am. I'm not a murderer, I'm not a killer, and I don't want them to, I pray for them as much as I pray for myself every day. I want them to know it. I know right now it's not something they're leaning towards. I'm just hoping that one day, instead of just coexisting, we can share a space and maybe share a laugh. I mean, but besides anything else, the phone calls don't help either, because I have had plenty of phone calls. I show remorse. It's used against me in whatever way to get a conviction. And I just want to say this is really who I am. A person with a heart. I want to say thank you for giving me the chance to speak.
Thank you. Does that conclude your comments? Thank you. We have 6 shots. Certainly that was demonstrated an intent to kill. And whether it's termed lack of remorse or coldness, as Mr. Fisher pointed out, I listened to those phone calls and I realized that there were over 1,000, perhaps 1,500 phone calls to your family and friends, and I suspect most of those conversations had nothing at all to do with this case. You're talking about family, talking about life. But for someone to make a comment, and I'm going to paraphrase this a little bit, obviously, like I only killed one person, like maybe 5 years. That demonstrates a coldness. And also comments that, what's the point of sending me to prison for a long time? The deceased is gone. Why make me suffer? And then you're complaining that Mr. McGee cooperated with the investigation because he's your friend. This was a homicide. If we're at the state in our society where friends don't do the right thing and say, this is what I saw on a homicide case, because loyalties to friendship trump basic morality, then our society is in a seriously bad situation. You seem to be advocating that McGee, why'd you talk to the cops? We were tight. And this is how he's doing me. You don't seem to recognize the gravity of your actions. The court will stay within the guidelines because the court does not believe that a sentence outside of the guidelines would be justified. By the same token, this court has to justify the sentence that it is going to impose within the guidelines. And the reasons that I have just articulated, the fact that for no apparent reason, you put 6 shots into this guy at point blank range. And it's like, what's the big deal? Maybe I'll get 5 years of this. Why should I suffer? Boy, that's horrific attitude, and that deserves maximum sentence. Because he sentenced of his court on the felony firearm charge that you served 24 months in the Michigan Department of Corrections. You have credit against that time of 507 days. That is consecutive to and preceding the murder charge, for which you will be turned over to the MDOC for a minimum of 270 months and a maximum of 900 months consecutive. That is the maximum penalty that the court can impose within the guidelines. I've articulated that this is justified within the guidelines. Restitution of $15,923.80. That is subject to a restitution hearing if that is requested. This is a final sentence. You have appealed by right to the Michigan Court of Appeals. You can fill out that application and return it within 42 days. Fill out the paperwork that you've been given. That is all. Sympathies to the family. Thank you. And frankly, sympathies to your family as well, because 2 families have been torn apart by your actions. That is all.